Can we skip the meeting because I do? We need not one.
Can hear desks.
All right, I want to welcome everyone today to today's meeting for the Medical Cannabis Policy Advisory Board.
You as well.
We will go ahead and get started. I'll read from the introduction script. So this meeting is being held virtually and is hosted by the Utah Department of Health and Human Services Center for Medical Cannabis based in Salt Lake City, Utah. Public notice of this meeting was provided as required under Utah's open meeting laws and was posted on the Utah Public Notice website. In compliance with Utah's open meetings law, this meeting is being recorded. The recording of this meeting will be posted to the Utah Public Notice website no longer than 3 business days following the date of this meeting. A rough draft copy of the unapproved written minutes will be posted to the Public Notice website within 30 days of this meeting. Approved minutes will be posted to the Utah Public Notice website no later than 3 business days after board approval. Every proposed agenda item must have a one-page summary of the topic submitted to MCPAB@utah.gov no later than 7 days prior to the board meeting. Board members will present the one-page summary during board meetings, and board members will discuss the summary. If no written summary is provided to board staff, the relevant agenda item will be removed from the agenda. Only items that have been submitted in writing in advance of board meetings will be allowed during discussion by the board chair, including presentations from the public. Board members will then request additional presentation and memorandums on those agenda items from relevant bodies to be presented at the next board meeting. Those presentations and memos will also need to be submitted to MCPAB@utah.gov 7 days prior to the board meeting. Public comment instructions. Public comments will be limited to 2 minutes per person. If you want more time, you must request it from the chair. The chair may accept or reject requests for additional time. A public comment period is not guaranteed every meeting. The chair has the authority to create or remove public comment period from the agenda or during the meeting. You can look over public comment guidelines that are posted on the Utah Public Notice website. Please state your name and your affiliation when making public comments so it can be reflected in the meeting minutes. Only comments made on items listed on the agenda will be considered. If you have a comment about an item not listed on the agenda, please email them to mcpab@utah.gov. To make a comment over the Zoom public chat will be disabled during Zoom meetings. When the chair indicates it is time for public comments, you will use the raise hand icon on Zoom to indicate that you would like to make a comment. When you are called on, you will be taken off mute. Take 2 minutes to make your comment. Those here present and in person, sign in on the public comment sign-in sheet with your name and indicate what agenda item you would like to make a comment on. The chair will indicate when it is time for the public comment period. The board chair will call on you when it is your turn, and you will come to the public comment table. Take 2 minutes to make your comment. As a reminder, if you're in person, please do not speak when others are presenting. Our mics are very sensitive and those attending over Zoom cannot hear when there is more than one person talking at a time. Side conversations and comments from the public during this board meeting are prohibited. Please use a voice that is louder than your typical one when speaking, commenting, or presenting. When you speak, please lean in towards the table as if there were a microphone. For additional information, to make suggestions for agenda items or to contact board members or staff, please send an email to mcpab@utah.gov. And with that, we will jump into our first item. Let's see, did everyone get a chance to read over the October 2024 minutes? And were there any changes or modifications that you made? If not, will go move to approve the minutes.
I'll make a motion to approve the minutes for October 2024.
I'll second that.
And all those in favor? Aye. Thank you, Kent. Good to have you. All right. Up next, we don't have any administrative business. So with that, we'll move right into item number 4, and we'll turn time over to Mr. Oborn for the Department of Public Human Service update.
Okay, so we've got just a few general statistics to share as of October 31st. From our reporting system, we have 90,523 active medical cannabis cards in our system, and then 952 QMPs registered in the program, and 75 PMPs or pharmacists registered in the program. And during the past month, there's been an increase of about 1,000 active medical cannabis card holders since last month. As far as other updates, EVS enhancements have been happening. One of those was that pharmacists working in medical cannabis pharmacies are now able to view contact information about the qualified medical provider that was treating a specific patient. They're now able to access that contact information in the EVS. And so that is something that was requested, and we listened, and we were able to add that viewability within the EVS. So pharmacists can now view that in the EVS. Also, the current EVS has medical cannabis product purchase history back to July 11, 2024. And we're working on, we project that by the end of the year, each cardholder's full historical purchase history data will be included in the EVS beginning from the beginning of the program will appear in the EVS. So that is something that's in progress right now. That'll be something that those working in pharmacies will be able to have access to, and patients will be able to have access to, we hope by the end of the year. Also, there's a proposed rule that is making its way through the rule hearing for that, and this is Utah Administrative Code R383-16, targeted marketing requirements. This is impacting qualified medical providers and how they advertise and how the clinic that they work for advertises. And so this rule hearing will be held tomorrow, November 20th at 11 a.m. And it'll be held virtually, but there will be what we call an anchor location that someone could come to if they chose to come in person. And someone can join by Zoom. So it's like a hybrid meeting. If someone attends in person, it'll be in room 2026 in this building that's on the second floor. And we've talked about the specific rule in a previous meeting, but it just relates to target marketing of recommending medical providers. The public comment for that is not limited to tomorrow. That's just the actual rule hearing. You can make comments in writing up until December 16th. And then the earliest possible effective date for that particular rule is December 23rd, 2024. And then
You say the comment period runs till Rich?
The comment period, comments will be received until December 16th. Yeah, written comments. And if you go to the Utah State Bulletin, the most recent one that was published on November 15th, that is the one that includes the rule. I've got a copy of it here if any board members want to remind themselves about what it says. But this was a rule that was required by legislation, SB 233, that passed last legislative session. So also the Utah Fall Conference on Substance Use. I was able to present at that with Dr. Matt McKiff at the Fall Conference. And the topic was strategies for safe use of medical cannabis. We had approximately 50 people there, I think. These are individuals that work in addiction treatment and corrections and social work and mental health fields. And Cami was there. I was glad to see a familiar face. Most of them were not familiar. That was one I knew. But we were glad to be able to share just some strategies for safe use of medical cannabis. It was a group that I think it was helpful for them to see how it's used in a legitimate practice that Dr. McKiff runs in St. George, and the principles that were taught are on our website. Under providers, if you go to, there's an assessment checklist that the Cannabis Research Review Board helped us put together that Dr. McKiff is a member of, and so is we've got a lot of members of that board. Anyway, so that was what the topic was focused on, was strategies for safe use of medical cannabis. And if any of you are aware of other opportunities for Dr. McKiff to present, please let us know. We're always looking for additional opportunities for him to represent the program and to share some of his insights. Also, I was able to do some testimony before the Kansas Special Committee on Medical Marijuana on October 28th. As some of you may know, Kansas does not have a medical program, but they are a state that has a similar population, and there's some demographic information that's similar to Utah. So often they're a state that's compared to ours. And so they had invited me to present and just to talk about how our program has been working, some strengths and weaknesses of Utah's pharmacy model, as they called it. And then they were also curious about the Medical Cannabis Policy Advisory Board and how that works. So I was able to share information about some of the benefit of our board, and that I also just responded to some questions that lawmakers had about our program. And this was before what's called the Kansas Special Committee on Medical Marijuana, and they voted later that day to decline to recommend legalizing medical marijuana in Kansas. But who knows what will happen in the future? We'll see. And then final item is just, I'll be attending the Cannabis Regulators Association member annual meeting on December 4th. And as part of that, I'll be moderating a breakout panel on structuring medical cannabis programs, lessons learned about what patients and clinicians want. So there's some other states, including Health Canada, that'll be there sharing some of the things that they've learned from patients and clinicians in various states and territories. Any questions about any of the items that I shared information on? Yeah, that's all.
Thank you, Rich. But we'll go ahead and move on to some of Mr. James.
Thank you. I got a couple of things to mention before we get into those items listed on the agenda, so I'll pause in between for a couple of seconds if there's any questions. First and foremost, not really anything to do with medical cannabis, other than just taking some time away from it initially, as it sounds like our division, so the Medical Cannabis and Industrial Hemp Division, is going to be also taking on Kratom as a product that we'll be overseeing and regulating here in the near future, probably by the end of the year, first of the year type of thing. So see what that looks like moving forward. One of the big, it's not actually currently under regulatory services there. So it's actually follows pretty close to our industrial hemp type of regulations there. And we'll take that over and actually be able to put some people behind it and do some work on there. So at least that's the thought at this point. So see how that goes. We're can't tell, very much looking forward to more work. So,
Well, you do love drugs.
yes, yeah. We are thinking of changing the name of the division and just make it so it's automatically a swear word.
Depending on who you ask, there's a four-letter word.
Yes, for sure. So, next thing is that does have to do with medical cannabis industry. Our cultivation renewals will be on December 18th. Obviously, there's been some issues, as so many of them, with our AIM system and getting applications in. So I know that there's been some emails back and forth on getting that information in and stuff. And we'll obviously be working with the licensees to make sure they get everything in that they need to before we get there. It is a little bit later in the month than it has been in the past couple of years, but I don't foresee really any issues other than getting the information to us and as needed. So hopefully that's the last time we have to do something where we back off and go to the old way of doing things. So many questions on the renewals or the licensing board? And the last thing I'll mention, talked to Dr. Forsyth before I came in, just wanted to talk again about the ICS. Sounds like they're still dealing with some data issues, some problems moving data from MJ Freeway to Salesforce. We had a short meeting yesterday, which pretty much just let you know we need to have a couple other meetings with some other groups over the next couple of weeks. So we'll have some working group meetings over the next couple of weeks. That should begin scheduled very soon. And then at that point, after we have that meetings or those couple of meetings, then we'll be able to actually hopefully have an actual go live date. You all say that or I'll say that with hands behind my back and crossed fingers, because we all know how that's gone so far already. So, but hopefully again, looks like we're probably thinking end of December, maybe now even into January, which I know won't hurt a whole lot of people's feelings if we finally move it into there, but that's where we're at on ICS. So.
Question on that. So there is a renewal for MJ Freeway that goes into effect January 1st.
I think that's one of the reasons, well, one of the many reasons we're trying really hard to get there for that. So there's been other instances as well, and getting MJ Freeway, to no fault of their own, really, I don't blame them, to go along and do some short-term things. I wouldn't want to do it if I was them either. Just had one of a processor that did get approved by the board, trying to get their license done at MJ Freeway, isn't wanting to do much with them, obviously, so we're working with that. So yeah, we're trying really hard to get to that point where that doesn't have to happen, so.
Thank you.
Yeah. Ready for me to move on to the market analysis? Okay, this should be kind of short and sweet, depending on how much the board wants to talk about it. As you all know, you've read the last year's and probably the ones before, but statutory requirements requires that there's an analysis of the product availability within the state. Up until last year, it was handled by the Department of Health and Human Services. It's now handled by the Department of Agriculture. We obviously work very closely with DHHS on this type of survey. One thing that has come up obviously every single year is once that survey or that report is put out there, we always get a little bit of feedback, kind of saying, hey, they didn't really say that, or we'd like to know more, things like that. So Department of Agriculture, and we talked to Rich about this, is coming to the board, to the MCPAB, to see if the members would like to give us some questions that they would like to ask patients and things. Obviously, as representatives of the state and the medical cannabis market and industry, I think maybe you guys may have some questions that you want to get answered. Again, it's pretty straightforward in statute exactly what it's supposed to be, but I don't think there's anything that says we can't tweak a few things to make sure we try and get some related information for the good of for the industry and the program.
Question on there, is it just specific to just products? What's the language say for your survey?
It is pretty much analysis of the in here too. So, the analysis of product availability in the pharmacies within the state. Is that correct?
Right.
I think I'd encourage you guys to look at the study we did earlier this year and dive into that 60% number. As 60% of people respond to that survey claim they're not sourcing their cannabis from a legal source here in Utah. Knowing why, because maybe it's that they're finding other products in other markets, whether illicit or otherwise. Because clearly here in Utah we don't have some form factors available that are available in other states. Things like that. I encourage you guys to look at that, that study and see if there's any questions you can glean from there, because we do know that the majority respond to that certification or otherwise are sourcing their cannabis from outside Utah. Interested to know why. And it's really about products, and that's what you're focused on. I assume we'll probably find that there's some form factors available in other states that are good.
And as I mentioned, I don't think there's an issue with going outside of that per se, right? I mean, obviously, we've done that in the past with the other surveys that DHHS did and what we did last year as well. So any information that you guys would like to see, we're happy to get that from the board. The idea at this point is to actually have the University of Utah handle the majority of this. We'll actually obviously have DHHS be the ones helping us send out information to patients. We get some surveys because it's the one, and it'll be, I think, more up to date. That's the right term, because it won't necessarily all be based on past history. We'll be trying to get some more up, in the now type of answers from current patients, and possibly if we can find a way to get those that have either left the program or those that, as JD has mentioned, part of that 60% or that whatnot that's getting it otherwise. So trying to get as much as we can, and again using a group that can really put this together a little bit maybe better than Department of Health or Department of Ag can do ourselves.
I think saying something about cost or affordability might make sense, but I think we all know the answer to that. From the study. So could we do like A, B, C, or D? Or do you find value in it? Maybe is a better way to put it. I think the other one would be is have you found benefits or success in your treatment? That might always.
Yeah, I think we're just talking about products, I get it, but also too, I can still ask questions about services that are being rendered at the pharmacies too. Because a lot of times what we hear is that sometimes patients feel like they're getting a better level of service from the pharmacy than maybe other folks that they interface with in the program. So it'd be interesting to know what their comments are about the services that they're receiving as well, not just the products they're able to purchase or not.
Yeah, and Jeanette, one of your points, I think that if there's a way to do it, and it doesn't have to necessarily be through this one, and it's something maybe we could get either the board to kind of stand behind or others, but to talk to our medical providers, right? They have a lot of information, not necessarily on the individual identifying basis, but as much as exactly, how much are people using, they can see some things, and there's some good information that I think they could help us gather. And I say us, I mean the industry and the program as a whole. So, obviously I'm talking about the market analysis for that, but I think as Rich and Dr. Forsyth said, and I think all of you have mentioned in one way or shape or form before, is that there's a lot of information out there too that we could be looking at too. But so obviously I'm more concerned about what I have to do statutorily now, but I think there's a reason to open up some other things too.
Is UDAF going to perform another market analysis just like they did last year?
This will start to be, that'll be what I'm talking about here is.
Oh, so this survey is going to be, so you guys are going to just do it yourself, not use an outside group?
We're gonna have University of Utah help us, and especially with the statistics. The HHS will be the one sending out the surveys, but we'll have someone else actually putting that together.
So this replaces the market analysis that goes on last year. Because I think it even underscores my point further that it needs to be broader than just, are you happy with the products you can find? Because obviously it's multifaceted. We've lost 56,000 patients in this program. And that's a multifaceted, it's a complex thing to understand. I think just whether you can find the right product at the pharmacy you're looking for just doesn't go deep enough, right? We should be analyzing all parts of the access, to medical cannabis in Utah, not just what's available at pharmacy, because I think that's only one part.
Yeah, for sure.
As a follow-up to question one, if they have the products that you need, if the answer is no, what products have you not been able to find, or what preparation have you not been able to find?
Education.
Yeah. I know that's not a bubble.
Not a true false yet, no. Yeah.
Well, you can put it in. We have categories and subcategories of products.
Yeah.
Especially in the new Salesforce and ICS, potentially tying to that so they can select.
Yeah, well, like I said, we will, I'll take this back. We'll see what we can come up with. We'll work with the HHS as well to do what we can with everything. And if you have any others, I don't think this necessarily needs to be just something that the board votes on or makes a decision on, but we're happy to take some input, that thing. But as the representatives of the different aspects, so I just wanted to come to you guys. It's a good place to get the information in a smaller manner than getting bombarded with emails. So
When are you looking at launching the survey?
Based on things, probably be first of the year type of thing. I mean, it's just just time frame wise, right? We still gotta make sure we can get some things paid for through whoever does it, even if it's not you, right? We are gonna have a third party of some sort do it, and that won't be us for the most part, and there's always money involved and hoops to jump through when you're the government trying to do that, so.
May even be worthwhile to have an open-ended question. Is there any other concern you'd like the medical cannabis program to be aware of?
Anything you wanna add there?
Yeah, if I could just add, Cody, so members of the public can email any feedback they have to cannabis@utah.gov. And if we could get any of that feedback by 5 p.m. on Tuesday, November 26th, that way we can know, okay, we've got feedback. Let's incorporate what we can, and
So is that our deadline for submitting
If-
information?
we'll always,
Yeah,
and UDAP will always take any feedback after, but it's just helpful to have a deadline.
To bring this up, to us at this meeting and say you need feedback on something that now is going to replace the market analysis that was done last year, that was what, a 30 some page report, and say this is gonna replace it. And right now, the questions that we see in front of us are these few.
It's not,
No, it goes beyond just this. This is just the one little one that was done in 2022, okay? And then many pages that was done in 2024, right? That was published. And, I mean, if the board requests more time, then tell us when.
well, and I would also go on to say too, I mean, I don't think that we want to, that at least the Department of Agriculture doesn't want to turn this into that we're waiting until May for input, or that we're just having someone come out and just completely go off on that they didn't agree with last year's thing. What I'm looking for is some questions to ask, to be able to get some information that is needed, I mean, if we don't have those questions now, I'm not sure that we're gonna be able to get them in 6 months, other than it just becomes something that we don't like. So I'm just looking for some, again, questions to ask to try and get some information that would be helpful for those of you at all. If it's something that we feel like it needs to be a deeper dive, then I think there is room for that in other aspects to do, and we can come up with ways, whether it's, and I think it was actually at this board meeting in October where someone asked, maybe it was even the month before, to put, to maybe have something legislatively backed, and I think maybe it was you, Dan, who brought it up, but some type of thing, but I'm sure it was then, so, but because this isn't the only thing that's out there to do, but this is where we're at, and this is what I'm asking for, so.
I think in a survey like this, if you're asking them if they're happy or satisfied with access, if the answer is no, they should have an opportunity to say why they're dissatisfied. Otherwise, you can't garner what the issue is.
Yep. All right, moving on to the couple of rules, R 66-10, the closed door pharmacy rule is one that I brought to you guys last month. Had some feedback from board members as well as some of the public attendees. And just wanted to revisit that and tell you guys what we had decided to do after receiving that feedback. So R 66-10-3, there's some concerns over items listed as what would be looked at when deciding who gives the licensees. When it comes time to do it as being subjective. Just wanted to say that many of the items listed in the rule are either the same or very close to what is listed in the statute. The department will also be, as we get to this point, putting weights on different aspects of this to be scored by the licensing board. Overall, as most applicants, especially going back to the cultivation one, and I'm sure DHHS with the pharmacy ones, we want to see what each applicant is going to do, what they're going to do, and how they're going to do it in order to be able to score those and see who the best applicant really is. So we didn't make any changes to that at all. We'll leave it as it is. And then as we go to put out applications, obviously there'll be more information added to that, along with the scores, or the scoring, or the weights, I should say, for how that's going to look. R 66-10-4-2B, there was concerns of keeping employee work schedules. Stating that it wasn't part of any rules at the time. We went back and reviewed the pharmacy rule, R 66-5-3-1BI, which requires actually the same thing. in that rule. So we actually decided to keep that the same, so that the pharmacies and the closed door pharmacies would be the same in the types of rules that they have. The one thing that we did change was R 66-10-9 on the under inventory. And I apologize first that I sent Trevor the one that hadn't been all the way fixed, but hopefully it's there now. Instead of requiring in rule that the inventory ought to be done every day as it used to be, as it said last month, or even week or even month, we'll let the closed door pharmacy decide on their own how they would like to do their own inventory audits. And the department will rely more on the statutory wording for inventory more than the rule and having it done daily, weekly or monthly. That's pretty much it for our 66-10.
Any questions from the board at all?
All right, so last thing is R 66-29 compliance procedures rule. This one is actually the last rule that we needed to bring over from our time at plant industry division when it was under the R 68 rules. It's kind of hidden even farther down there, but during our time as the division was related to plant industry division, we used their compliance rules as ours as well, and theirs was R 68-19. We brought this info, pretty much the same information over to R 66 for this, which is now the hemp and cannabis division rules. And we did update some of the information with policy and words that we actually use. I want to go on to say that every regulatory division at the Department of Agriculture and Food has their own compliance procedures rule. Animal Industry Division has R 58-19. Plant Industry has R 68-19, and Regulatory Services Division has R 70-201. All are their compliance procedures rule, which are very similar in their wording to what this rule says here. Having this rule is actually required by the Utah Administrative Procedures Act. I do also need to let the board know that the rule does not change or even regulate the medical cannabis or hemp industry. It actually outlines what the department needs to do in regards to what authority you've been given for these things. So I want to go through some of the differences in the rules from R 68-19 to what it is currently, as well as the authority given to do so. Just as quick as I can, R 66-29-2, the definitions. We did add the definition of cease and desist order. It's not in the plant rule, so we added that definition as well as the portion at the bottom, which I'll talk about in a minute. The authority to do cease and desist comes in the statute 4-8-106, 4-41-106 for hemp, and 4-41A-402, and 4-41A-801 for medical cannabis. The division obviously changed in definitions from plant industry to medical cannabis and hemp. Hold order was added to that. It's a part of a larger definition under the plant industry division, which actually calls them emergency orders and has a number of them that they can do. We just went with hold order. Authority given to us to perform hold orders is 4-41A-702 and 4-41-106. We added corrective action to all of these different aspects, whether it's citation, hold order, the rest. We added a corrective action required, so licensees or whoever actually got the violation has the knowledge of what needs to be fixed in order to get that hold order or whatever the situation is removed. The corrective action is not something that's actually in anybody else's rules, but we figured for transparency reasons, that would probably be a good thing to have in any of our letters or paperwork. R 66-29-4-3, you can see that the violations are up to $5,000. The authority to do that is under 4-2-304. And actually that says in both of our statutes under 4-41A-801, 4-41-106, that violations can be up to $5,000 there unless otherwise specified in the statute, which I think that has to do with the agents where it lowers that amount. The 20-day timeline for cannabis is different than the 30-day because in 4-41A-801, it does say that it gives a 20-day timeline. And then R 6629-5, back to the cease and desist, and also the suspension of the license portion. This is new language, that's actually providing us with the accountability, there on what we should do and when we can do cease and desist, or when we should do it and how to do it. The cease and desist authority comes from 4-8-106, 4-41-106, and 402 and 801 of the medical cannabis statutes, as I mentioned above. And then the suspension of license authority is 4-41A, 801, 7B, and 4-41-106, 8B. And then the last thing that's a change, just more for clarification purposes to the industry and those who receive a citation from us, that R 6629-7, number 2 states that if a citation is challenged correctly, the timeline is suspended. So you don't need to worry about anything doubling if it's again challenged correctly. So those are the reasons and the authorities that we have to put that rule into place. It's something that again is required by UAPA, as well as the rest of the department's regulatory divisions. So that I'll turn it back to the board.
Thank you. Any comments on anything we've heard from Mr. James today? We will, if that's the case, we'll go ahead and move on to our next item. It's item 5, medical cannabis use by participants in problem-solving courts. We will go ahead and turn some time over to Mr. Dressel. Want to go ahead and take a seat?
Thank you, board members. My name is Michael Drexel. I am the Assistant State Court Administrator. In that role, I work at the Administrative Office of the Courts, which is staffed to the Utah Judicial Council. In the Utah Constitution, the Judicial Council is obligated to administer the judiciary and works hand in hand with the Supreme Court, which governs the practice of law and the creation of rules of evidence and procedure. So I'm here as a representative of the judiciary. And more particularly within the judiciary, there are advisory bodies, much like yourselves, on issues related to specific subsets of the work. In your case, medical cannabis policy in the state of Utah. Within the judiciary, there is what's called the Board of District Court Judges. There are 78 district court judges in the state of Utah in 8 different judicial districts. And this board is elected from among that group by their colleagues to make recommendations to the Judicial Council as far as it relates to court operations. And they are a group of conscientious judges that are trying to grapple with legitimate problems. They have created a proposal that I drafted a memo about that you would find in your materials that would propose a tweak, a change to the current medical cannabis policy as it relates to court-involved individuals and what a court can and can't do as it relates to that individual's use of medical cannabis. The challenge that we're facing is not all court-involved individuals, but rather a subset of court-involved individuals, people who are brought into court on significant criminal charges and they're facing likely prison sentences because of their criminal history and their criminogenic profile. And this subset of individuals often has substance abuse disorders that drive their criminal behavior. These groups of people historically were not handled well. And I'm talking decades ago, it was like, well, we'll send you to prison or jail and we'll figure out if some time in custody solves your problem. But as we've learned and as we've all grown in our understanding of addiction-related issues, that is not a solution to the problem. It just exacerbates the problem and creates new and additional problems. So about 20 years ago, 25 years ago, there became an effort to grapple with this group of individuals in a different way. And it was through this that there was the formation of problem-solving courts. You may be familiar with things like drug court, mental health court, veterans treatment courts, family dependency courts, DUI courts. These are special calendars of cases that are comprised of individuals who are largely suffering from the same types of problems and are bringing them into the criminal justice system. In fact, just to give you a sense, there was a drug court and adult recovery court in Utah that had a graduation just the other day. One of the participants who graduated had 11 cases was looking at 39 years in prison, 23 years old. These are some of the people that are in problem-solving courts, and it's across the state of Utah. For 5 or 6 years, I administered a problem-solving court, a drug court out in Uinta County in Vernal, and had firsthand knowledge of, I think, something that will resonate with you, and that is that on paper, people can look horrible. But then when we get to know their circumstances and their situation and the challenges that they faced in their lives and things that drive them to the behaviors that are getting them in trouble, the human element is very real. And the drug court program and the treatment court program, mental health court programs, et cetera, are really geared towards trying to help the individual overcome their challenges. Now, in the medical cannabis context, the current statute in 78A231 contains 2 subsections that are, I know some of you from talking with you don't see it this way, but from the judges that manage these court calendars, they see them as being in tension with each other. Subsection 2 of that statute says, paraphrasing, that court is required in any sort of proceeding to treat medical cannabis use that is lawful under the statutes of Utah, the same as any other prescribed controlled substance. Medicine is medicine, and we're going to treat it the same, I think is how I would summarize that. Subsection 3 says that a court is prohibited and cannot require somebody to abstain from the use of medical cannabis as a condition of probation or plea in abeyance or diversion. And so in the treatment court context, the way in which these statutes, these 2 subsections butt up against each other is, again, paraphrasing. You have to treat this medication the same as any other prescribed controlled substance, but also it's different because unlike any other substance that a person might be using in a problem-solving court context, which can be managed effectively by the treatment team in the court, this one you can't require a person to abstain. And that tension has created this proposal, which is that we are hoping for your feedback and your support, frankly, with a proposal that would say that in the treatment court context, that prohibition against requiring somebody to abstain would not be applicable in the following circumstances. If a treatment provider in the problem-solving court team determines that it would be a barrier to the individual in the progress of their program for them to continue to use medical cannabis. And if the person knew coming into the program that there was a possibility that that determination might be made, and then if that determination is communicated to the person and to the court, then that individual, in order to advance their progress in the treatment court program, could be required to abstain from medical cannabis use. Now, I can understand why I don't want to speak for any of you, but I can understand why this type of a proposal would be worrisome and concerning, that it reduces patient rights that have been so hard fought and won, that it might be abused, that it might become a hard bar, a barrier to people having access to medication when it isn't contributing to it's not creating a barrier to the progress in the program. The challenge I think that we're grappling with is actually one that is not really court managed. It's a treatment managed problem, and the court happens to be at the center of trying to oversee the problem-solving court calendar. The treatment problem, I think, is this: out in the community, an individual receives a recommendation from a qualified medical provider to use medical cannabis. And that is one relationship that individual has. And then in this other part of their lives, they're heavily court involved. They're meeting with a treatment professional and a team of individuals regularly, multiple times a week, in group sessions, individual sessions, testing, community supervision, regular court appearances. And this group, if they make a determination that the medical cannabis use is a barrier, currently the way the statute is written is that the qualified medical provider's recommendation really carries the day, and that the treatment team who's working so intensively with this person in their recovery doesn't have the ability to say, hold on, this is a barrier. What can we do about that? And what this proposal would, I think, in essence do is it would flip it so that while the person is in this highly structured program working on recovery and actively being accountable to the court and to their treatment team, that the determination of this group would, in essence, carry the day over a qualified medical provider's recommendation. Now, I saw a memo from Kindly MD that was circulated a little bit late, and they were thinking along some of the same lines that I was thinking on after a conversation with Desiree, actually, as one of the board members, and that is that the proposal as we sent it to you doesn't require the treatment provider in the problem-solving court to consult with the QMP as part of the determination as to whether it's a barrier. That's an error in the proposal that we sent to you. It should absolutely require consultation, or at least a good faith attempt to consult with the QMP to hear what the QMP's reasons were for recommending, and for the QMP to understand the issues that the treatment court is grappling with. And then to, by virtue of that conversation, come to an understanding about what the right path forward is for that individual. That type of consultation is actually standard practice in other contexts for controlled substance use for people in problem-solving courts. And let me give you an example of that. When I was managing the problem-solving court as an administrator out in Vernal, we had one of our participants break their leg in a motorcycle accident. And when you break your leg, you need some medication to deal with that. He had to have surgery to reset the bones. And this individual and his medical treatment team for his broken leg consulted with the treatment team, and we were able to craft a management plan that also served his interests in getting the medical care he needed for that acute situation, as well as continuing to advance in the program and not having this access to opioids in his life, which was a primary substance for his abuse prior to entering into the program, and that drove his criminal behavior, that it didn't become an opportunity for him to backslide in his recovery. Obviously, you would need releases and waivers and consents in order for these groups to be having conversation, and we're very accustomed in the treatment court context to getting the right waivers and releases in place, so we respect people's privacy. But that type of collaboration is the sort of collaboration that we would see as being a very reasonable and necessary component to make a proposal like this work. Another thing that I saw articulated in the memo that Desiree presented as part of the Utah Patients Coalition, is that right? Utah Patients, thank you. Position on this is accountability. And it's not in our proposal, but I drafted additional language that would require data collection and tracking about how many people apply to be in a treatment court program and have a medical cannabis card. Of that group, how many people a determination is made that it would be a barrier. And then of that group where that determination is made, how many are required to abstain, so that we can have some understanding about the scope of impact from this proposal if it were adopted into legislation. I think one of the things that I'd like to emphasize, and then I'm open to questions, and obviously I'm here to learn about your positions and opinions on this as much as anything, is this. There are, 3.2 million people in the state of Utah, roughly. And as I understand it, there are just under 100,000 card holders, maybe 90,000-ish card holders. There are about 3,500 people in problem-solving courts each year. And so, I'm doing simple math, but I do wonder if we're talking about maybe 100 or so people when you look at the percentage of population who have a medical cannabis card and the number of people in problem-solving courts who might also then be part of that population. That doesn't diminish their rights, each just because it's a small number. It could be one person. We don't want to make the wrong decision just because it's a small group of people. We want to try and help these people succeed. But ultimately, this subset of people, and I say this with all due respect and all the love in my heart because I know some of these individuals well from my work with them, their lives are just off the rails, dysfunctional, and because of their substance use. They are, as we would say in the problem-solving court lingo, high risk and high need. High risk to continue reoffending in the community, to hurt themselves and others. High risk that they will continue to commit criminal offenses, and high need in that there is no other intervention short of an intensive court-managed treatment program that can really help them break the cycle of addiction and move towards a more stable place in their lives. But we want to see these people succeed. These are amazing individuals and human beings. And the proposal is designed not to whittle away at patient rights in the medical cannabis space. The policy for the state of Utah, it's designed to give us some latitude to help do everything in our power to help these individuals succeed, not punitively, but as an opportunity to remove any possible barrier so that they can get to a stable, active recovery, not go to prison, not go to jail, be contributing members of their communities, be members of their families, right? Where they're active parents and where they hold employment, where they feel good about themselves, and where we don't have to house people unnecessarily in prison just because that was the solution that worked for so long, right? So that's what's driving us here. I'm open to questions. I'm open to feedback. I hope that you'd be willing to share openly and honestly with me about it. We really do want to understand this. We would never consider taking this to the legislature without first talking with you, and we respect your opinions. So with that, I'll stop talking.
Thank you, appreciate it. Go ahead and open up to the board for any questions or comments that they want to make. Sure.
Clarifying. So if somebody's entering a problem solving court and they choose, not to go to problem solving court because they could risk losing their medical cannabis right, they choose jail, basically, right? So that's one thing that we have to all remember is, and which they would play into that knowing they're not getting cannabis there as well, right? And so, but that is what hangs in the balance of them choosing this problem solving court and this, this treatment pathway out. You know, I have a lot of feelings, but just because I also work with a lot of these people, and I have heard on my end, I get the success stories, right? I get the people that are like, I can do this if, and we're able to, in the beginning, I was much more hands-on as we kind of worked with these problem solving courts and stuff in getting them to believe that they had access to medical cannabis while they were in these programs. And I saw some successful people. And so for me, well, where like I said, I don't love this, but I can see also that, and because when we did this, we didn't want, the purpose was to never let a judge or somebody in the, somebody else override the doctor's decision. And that's where I think the piece of collaborating with the QMP comes in. I mean, I got a little wordy when it's like, okay, and if they won't, because the assumption here is maybe we do have a couple QMPs in the state that maybe are still writing cards for the $200. Well, let's just say that number, maybe we can ask it in our survey. We just ask that question, just out. And so the idea is that maybe some of them are writing hard to get the $200 and they don't care about the patient. Well, in that case, is that the patient's fault? I mean, they did their due diligence to find a doctor, right? And to plead their case. In that, what can we use to fall back on? And I know mine is compassionate use board. I don't know if that's the best option, but having something where if you guys reach out to I mean, Tim's gonna respond. He's gonna respond every single time. But if someone doesn't, where can you send them? Is that the last thing that happens? They reached out to the QMP didn't answer, and maybe they never even got the email because somebody didn't open it, but then the patient's card is revoked. Should we have like an appeals process? And my mind just went straight to compassionate use board. They're there. There's 7 doctors. Could they kind of work on a collaborative care with them during this and in those situations? And I'm fine if they go to the compassionate use board and the compassionate use board says, and they talk with your therapist and they're like, no, I don't think this is the best one. Then they remove it, end of story. But I do want some kind of fallback on just in case the QMP didn't answer. I talk to Representative Red all the time and he's always like, we don't have time for that. That's his #1 statement about QMPs. Whenever I'm like, hey, could we do this? He said, we don't have time for that. And so thinking about time and just doctors, that was kind of, so anyway, I like to ramp, but if they collaborate, they were willing to meet with the QMP, if there's some kind of statistics, if we can check how often this is happening. And if there's kind of a fallback, if they can't get a hold of their doctor, I think for me, it makes it feel a lot more patient driven than, you know, just. I also should say, I sat through a lot of these meetings in the beginning, and I did not hear one positive cannabis statement. Well, that's been years, from these treatment facilities, and so I have that bias where I'm like, will they just remove? And so I want to protect against that too. So those are kind of my thoughts. Obviously, we need to flesh this out a lot, but that's kind of where I'm at. Not a question, sorry.
Could I respond on one
I would love
observation?
it,
you made?
yeah.
I thought about your compassionate use board proposal, and I wondered if it wouldn't be simpler to just require that the individual find a QMP who's willing to collaborate with the treatment team in the problem-solving court. I don't know what the rules are. If there's policies against that, that might be seen as doctor shopping or something. But at the end of the day, there are, as you say, QMPs who would be contributing members to the conversation, be open to that. And if we can connect the patient with that type of individual, their treatment plan is going to be well served for multiple reasons, I would think.
Good idea. The barrier to that is the cost. So if they go to new PMP, they have to pay that cost again. The compassionate use board is free.
I see what you're saying.
And we get a more robust team of doctors, like, you know what I mean? So I'm fine with either way. You guys either decide, but there is that extra barrier of cost that if they don't have the $200, then they just have to get up their medication. You know, so that's why I went there. Is it also is a free option?
I see what you're saying.
And we could like legislate that those doctors have to pay attention. You know what I mean?
You guys have any current statistics, not cannabis related, on people in your programs that are required to abstain from substances, obviously not illicit substances, but legal prescribed substances? Because as you and I talked about, over the phone, my concern is that this is going to be used as a bludgeon and not as a scalpel, right? That, you say a lot of things about how these are individualized treatment plans, but people's experience in the criminal justice system when it comes to substances is usually abstinence, right? Now, we've looked across the country, and I appreciate Trevor providing some statistics and some other research on this. But generally, if it's abstinence based, it's abstinence based, right? And I think what we're missing here is the federal government has recently made a pronouncement that cannabis is medicine. I know it hasn't been quite presented yet, but there's 200 plus pages of unredacted information that shows cannabis as a medicine, right? So even when you and I spoke over the phone, there were some comments that you made, about cannabis potentially being a gateway drug and some other things that just still don't sit right with me and my experience with the criminal justice system as an attorney. It's very, very similar. So I guess my real question is, do you have statistics available that show that this is a much more pointed, well thought out, well analyzed, type of system, as opposed to just, man, reefer madness and cannabis is bad, and we don't think it, we think it's going to be a barrier in everyone's lives? Because I think that's the concern, that I've heard voice. So do you have those generalized statistics you can share?
No, we've not been tracking that because we haven't had a need to, right? And so at the end of the day, we wouldn't have responsive data on that. I can say this though, over the last decade in particular, maybe 15 years now, treatment courts have moved from a model of strict abstinence to a model of, if medication can make a difference to your recovery, then you should be afforded the opportunity to use that. It wasn't that long ago that having somebody in a problem-solving court and having them use Suboxone, right? Or being a part of a methadone clinic, or taking Vivitrol, or something else that is a medication that is administered to them to help them maintain their sobriety, would have been completely out of the question. The people would have lost their minds. But now medication-assisted treatment is not just accepted, but it's deemed a best practice standard for problem-solving courts. And if medical cannabis is truly going to be considered a medication, then it has to fall into that milieu of substances that may be helpful to the person moving forward. So although we don't have the data for it, I would say this, medication-assisted treatment is more accepted than ever. And in terms of treating medical cannabis the same as any other controlled substance, we have every individual that comes into a problem-solving court program may end up needing some medication at some point. They may come in because they've been on benzodiazepines for their entire life, manage anxiety, or sleep issues, or they've been taking Ritalin or some other ADHD medicine for years before they even got involved in the criminal justice system. We don't automatically, and in fact, the best practice standard is to say we cannot just terminate your use of a beneficial medication. That is irresponsible. It poses grave health risks to the individual. It's a decision that gets made in consultation with the prescribing physician. And ultimately, it's a decision that isn't a judge-based decision. It is a treatment-based decision. There's not a sanction that is consistent with best practice standards where you sanction somebody by saying you can no longer use your medicine. That's not acceptable. And so I understand your concern, and I get what you're saying about a comment I made to you as cannabis maybe being a gateway drug, but that was in response, I think, to a perception, and probably rightfully so, that medical cannabis can also help people avoid uses of substances that are far more dangerous or damaging to them at the back end of their use. And I think it cuts both ways. In some instances, it will bring people into more serious use, and in other instances on the back end, it can help them maintain sobriety by giving them something to use that is not going to derail their life. And that's the only context I meant. I didn't mean for that to be offensive in any way, shape, or form.
Another question I have is, can you help me understand what the analysis looks like? Like, you know, for when you're doing analysis of whether or not to remove the right to consume, you know, a legal substance, and ultimately who is the decision maker, right? Because is it majority rule if you've got a 5-member team and 3 say, hey, they should stay on it, or 3 say, hey, they should be prohibited from consuming it? I just want to know ultimately who's going to be the decision maker and what the analysis looks like, you know, to get there.
Sure. I think the analysis would look exactly like it would under subsection 2 of 78A2231, which is we're going to treat it the same as any other prescribed controlled substance. And that is not a decision for members of the team who don't have medical or treatment-based expertise. So multidisciplinary teams in problem-solving courts are comprised of the judge, court staff, a prosecutor, a defense attorney, community supervision, often in the form of a law enforcement officer who's making house checks and employment checks, other social service providers that may be building in service, and then the treatment provider that's doing the cognitive behavioral therapy to help address the underlying addiction issue. None of those people are qualified to say you should or shouldn't be using a particular medication, except for treatment professionals who have specialized expertise. And then in consultation with prescribing doctor, or in this case, the QMP who made the recommendation, to make a determination. And that's why I will tell you, I mentioned this on the phone in some conversations, but the initial version of this proposal was just to say that a judge could require a person to abstain if they're in a treatment court. But it's not a judicial decision. It may be judicially enforced, as all court orders and treatment plans within a program like this would be, but it is a treatment decision. And so the process, I think, JD, would be very much like if somebody comes in and needs to continue using some other medication, and there would be a conversation about whether or not that medication is going to inhibit the ability of the person to proceed and advance in their recovery in the program. Are there other alternative medications that could meet the same purpose but have far less addictive capacity for that person that have been tried or not tried? And can we work towards seeing what other options exist so that the person doesn't have to carry a substance through the program with them that slows their progress or ultimately derails them?
So ultimately, it would come down to treatment provider, whoever that is, in consultation with the QMP. That would essentially be who would be the final decision.
I believe that's correct. And I will say, yes, that is correct. And I would say this, there are instances where there become maybe questions of fact about whether or not somebody's assessing the situation correctly. And people always can afford themselves of the relief of the court to have an evidentiary hearing and make a determination about which of them are, you know, the more founded in best practice and evidence, right? This is a totally different topic, but it happened in the Union County drug court. People were coming into drug tests, and some of the samples from certain individuals were coming back very diluted. And that ends up, you know, too much water content in the urine means that the drug levels are not what we would expect them to be. And they would say, hey, I did not drink excess liquid that would cause, and ultimately, because liberty things in the balance and participation in the program and other things, we had an evidentiary hearing. We brought out a nationally renowned expert, and we brought the people who were testing the drug samples and the individual participant who might have been in trouble, who has a defense attorney in the program. We all got together and had a hearing and talked about what the science was, what the needs were, as it relates to that individual. And then the judge was able to make a determination based on all the information. That's a rare circumstance, but it's a safety mechanism for somebody who says, look, this medication is not a barrier to me. My treatment team here is unfairly, prejudging the situation. Let's bring in my QMP. Let's have a hearing about it. I'm not saying that's going to happen every day. I'm not going to say that it's going to happen for every participant, but it's an avenue of relief for people. The judicial process is about litigating disputes and giving people fair opportunity to be heard, and it would be that way in this context.
I can say on behalf of the treatment provider community, it's not, there's been an evolution in that community, and it's not such an abstinence-based feeding of the drum. There's a lot more openness to different like medications and other things. We realize that not one shoe fits every single patient that we see, and we need to be aware of that. We need to be sensitive to that, but we also need to be aware of risk, and everything is about reducing potential harm. And by being collaborative with a QMP and being involved in this process, I think we can better meet the needs of the people in these courts, because there are people that need, different interventions and different approaches, and it's a very disjointed situation right now. But I think by being able to have a statute that really supports collaboration with the QMP in the context of the court, we could better meet the needs of the folks in these courts, and we could treat cannabis like any other medication in that way.
Ask one more question. I think the other question is, so in the instance that the QMP and the treatment provider disagree, the person then has to go spend money on a defense attorney and essentially go pay for an evidentiary hearing to prove their QMP correct, who already made the recommendation. Like, my question is, what happens in the instance that the QMP and the treatment provider disagree? You gotta go in front of the court and pay to have your dispute settled?
Yeah, great question. So every problem-solving court has a defense attorney that's there to represent individual participants in the program. Yeah, and they don't, or they're on contract, right, through the program in some way, shape, or form. Now the person doesn't have to use that attorney, but when legal issues present themselves, oftentimes it's that attorney who provides legal guidance in a collaborative way, typically, but can be adversarial if it needs to be, affect the individual's rights. I think the question would come down to whether or not the individual felt like, in consultation with their attorney, that they could demonstrate that they were being treated somehow unfairly, or that their right to use a medicine that was legitimate was inaccurately being deemed a barrier when it really wasn't. I don't know how often that's going to come up. The reason I say that is because of the collaborative nature of these problem-solving courts. They really aren't about us against them. It's a we're in it for each other sort of approach, truly and honestly. It's not uncommon to have rounds of applause, judges, hugging people and having pictures taken with them as they graduate. It's not the cold and distanced criminal justice system that you might think of. That's not to say that there will be people who always feel like everything is perfect. But most of the issues, at least from my experience, have been able to be resolved through collaboration with the team, because we're trying to find a way forward for the person to be successful, not trying to punish or diminish them.
But my concern is that the patient is the one who's gonna pay, and in time or money, I think the scenarios could both affect them really greatly. But I don't care about that. The patients just might have to end up paying in the long run. Can you tell us how often are you guys actually running into this problem? And I have to be honest, like, it's always that, the owl is right here, no one can still hear me. I am here, to protect patients' rights. with medical cannabis. I also have followed family members and dear friends through treatment work. And, I am torn because I know some that have been completely successful because of this. And I can also see instances where this could hold me back. So can you tell us, like, how often is this happening? What lets you know that it's the cannabis that's stopping them furthering treatment? I mean, that's kind of where my head keeps going, is how do we know? Like,
My experience obviously is totally anecdotal, and just speaking broadly, more broadly than just the treatment population. I can say that I regularly assess clients that have an active cannabis use disorder and a medical cannabis card that have it prescribed for post-traumatic stress disorder and do not meet criteria for the disorder and haven't ever. And they've had bad things happen. Yes,
they're not.
they do not meet criteria for diagnosis. That have active psychotic symptoms and have a medical cannabis card. I see that regularly, and it concerns me. Because I wouldn't be here if I didn't think medical cannabis has its place. It's an important thing. But there is this little piece of this population that raises this weird red flag. And I think there need to be protections for them. Because it could be potentially harmful. Can I say every single one of them is being harmed? They're being hurt. Oh, I wouldn't argue that. But is it a red flag for me? Yeah, it is.
So in that situation, you would remove the ability,
No, I would not. I would send them to my physician. And they would have a conversation with them too.
so that physician could just talk with their physician too, and.
Right. For me, it's like, I go, ooh, gosh, this worries me. So I send it over to my medical professional and say, I have a little bit of red flaggy stuff happening. Do you mind meeting with them? And I've usually spent between an hour and 2 hours with them at that point. I send them over to my medical professional who sends another hour to 2 hours with them. And then they go, either your red flags are weird, calm down, or they go, I have kind of the same things. And then they can collaborate with them. That would be our process.
And also then if all of a sudden, so say you remove the cannabis, but then all of a sudden they're like, that's it. I'm gonna go get some, opiates on the street or whatever, and they relapse into something worse. You guys could also reevaluate then and say, okay, let's try again with cannabis, right?
Our policy as an agency, again, this is just the agency that I'm with, is very, like, everything's an open conversation, everything is very individualized. It's not about like, well, we closed that door and it's closed forever, you know what I mean? We really want to see people succeed. But it's a weird slippery slope with, like I said, this little subset of this population. It's a hard thing to navigate. And I think the courts are trying to find a place to navigate that too.
Well, and I have to be honest, like a lot of my fear is what I have seen from the courts, but I have, you have this fear, like, are they gonna just come in and just throw the hammer down and it's over? But I've also said, seeing people go through these courts and there is a lot of love, there is a lot of support. And I can't say in an individual, me watching that individual go through these, I've ever ran into a situation where they were unwilling to listen or just, so they did love them and care for them. So I'm torn, like you can see, like, do I want to make a broad brush, like, yeah, you can take these away? No, but I need some kind of comfort to know that it's going to be used to target these ones that need the help and not affect them. And I just wish you guys could just give me 100% guarantee.
I think you've fought very hard in a system that especially historically has been very resistant. And so I get where you're coming from. You come from a space where you have fought tooth and nail. And I guess all I would ask is to recognize that the treatment community we're progressing. We may be slower than some other spaces, but we are progressing and we are recognizing the potential benefits. And so to give us a little bit of room to prove our progress and to, come into line and be a better community partner.
The compassionate use board, I feel like sending it to them would mean more money and more time with the patients as well. Because every time you see the compassionate use board, they have to go and see their so we might be charging them a fee as well, and they only meet once a month. So between those two things, that is gonna be a lot more time and money for a patient. Something to really think about. But you can't just say, if the QMP is not gonna manage this and her doctor can't talk to, like Tim all of a sudden is like, I don't wanna deal with you. Then her doctor can go to the compassionate use board and work with them. That patient doesn't have to pay, they only have to pay Tim to take it. Right? Am I right, Rich?
Well, this proposal that you've come up with,
I.
It,
A bunch of statutory changes.
It totally
right?
does.
well,
Well,
it-
with the compassionate
yeah,
use board.
it would require statutory change, obviously, and I'll just, I mean, we don't have a position on it, but just some things I'm thinking through is, based on what I've heard, it seems like it would be low volume, extremely low volume. The volume of cases reviewed by the compassionate use board has decreased and is decreasing over time. So that's a factor to consider. They meet monthly. So there'd be this need to, you know, by chance, the request comes in at a certain time, making sure it gets on that next agenda, potential need to wait over 30 days for something because of the need to review that case. And the compassionate use board, as they review cases, they rely heavily on the petition submitted by the QMP that they're assigned to and treatment information from that provider that they're meeting with, right? So the QMP, they're coming to the board because the QMP has not been reachable.
Right.
So they would need to find that somewhere else in order to make an educated recommendation. Because what they rely on to make recommendations is this QMP proposing that this patient who is a minor or who is an adult who does not have a qualifying condition receive a card, right? So there's just this question of what evidence are they going to rely on
Right.
in that setting? So it would be whatever arranged for the court, or yeah, what they would get through the treatment program, right? Something we can talk about more after this
They would
meeting.
be willing to, that's the thing, because like they haven't seen the patient, could the patient have their medical stuff just sent there? And then they could become basically the QMP at that point, through treatment.
The medical provider at the treatment center would be the
No,
Q.
no, no, the compassionate use board would kind of like just become the surrogate QMP through treatment.
Yeah, you know, I think what we could do is just talk about this more as we evaluate what's possible and what's not. It's worth evaluating. So we can talk about it more. I think there's some possibilities to consider as we think about using them as a resource in this particular type of law change. It's possible.
I think in terms of feedback for your current proposal, though, one consistent thread that I've thought and I've heard from everyone who's spoken is there needs to be some involvement and contribution from a QMP.
And some transparency on how
Yes,
things is done.
exactly.
And I think those are the two things we can all say, that only makes it better.
Yeah.
But, you know.
Yes.
Yeah, very grateful for those contributions.
Yeah.
And I actually regret not having them in the proposal initially because they make so much sense. It may be worth, and I don't, far be it for me to make suggestions at all, but I guess I'll hazard to, if we could identify a funding source where there could be a unified QMP, a go-to QMP for treatment court purposes, so the patient doesn't bear the cost. But so that there's an opportunity for the QMP to be familiar with the treatment court model and best practices for the treatment court staff teams around the state to have a centralized resource to connect with when these issues arise. We may find that we have a lot more consistency in decision making and common understanding about issues.
Yeah, that's something to think about. Yeah, Des, what we can do is just talk about things more after.
Yeah.
As you prepare, your position even more than you have already from the Utah Patients Coalition. We can visit more about it.
Are we voting on this?
Oh, we have a comment first.
Well, I was gonna vote first.
Oh, no. I mean, I do want to take some time for public comment. We do have some people that have written on there. I do appreciate the time you've taken, Mr. Drexel, to present. And now, real quick, did you say I mean, I know you said you wish you had added some things to your recommendation. Have you made edits to it since reads from this copy that we're seeing?
I have a draft that I shared and reviewed with the Board of District Court Judges on Friday, and I'd be happy to provide that to you all to see. But in essence, it's exactly the proposal you have in front of you with the following changes. It says that the treatment provider, in consultation with or after attempting to consult with the QMP, and then the paragraph continues unchanged. And then a new subsection after the fact that says the administrative officer of the courts would be responsible to collect the data on how many people attempt to enter into a treatment court with a medical cannabis card, how many of those have a determination that it would be a barrier to them, and of those who it's determined to be a barrier, how many are required to abstain. I think what we'll find is that in certain treatment courts, like mental health court, it may be that it's determined to be a barrier for a lot of people because of just the nature of the underlying issues. But that in veterans treatment court, for instance, it may never be a barrier at all because post-traumatic stress might be the common denominator for many of the participants. And then in the adult drug courts, it may end up being that it's a mixed bag. I don't know. But ultimately, I think having that data and then being able to submit that and review that is a key part of this.
I think we'll go ahead and thank you for your time. We're going to turn time over to those that are in the room. Start with signed up Tim Pickett.
Thank you to the board. My name is Clay Pickett. I represent KMAMD. We take referrals from the justice court system in problem solving court. And they have looked at this issue similarly to try to get a QMP and a group that has experience with the addiction protocol, but also understands the situation for the patient. And so that was, related to my comment and, my written comment with regard to, I think what it sounds like for us was that the situation is that the court needs trust, and they need to trust the QMP. I think that there will be a difficulty finding a lot of the QMPs who issue the cards to these particular individuals. And that has been a problem. So the court has come, looking for a inexpensive way, that would be covered under Medicaid or subsidized through a free program. And so, however, I think the bottom line for us as medical providers is that really it does need to be we need the decision-making authority to revoke the card, plain and simple. If somebody is going to have surgery and they can't use cannabis for 3 days, it is what it is. And it may be something that medical provider, we have to educate the medical provider who's in that treatment court and then we have to trust them.
Thank you. Thank you, Tim.
Thank you.
All right, Shane Erickson.
Hi, everybody. Thanks for letting me talk briefly. I'm Shane Erickson with Empathetics Wellness Clinic. We do medical cannabis treatment in our clinics across Utah, but also I am a founder of a program called Men's Tribal House. And we're a 27-bed licensed men's recovery residence in Midvale. And we're the first program that started not only allowing cannabis with our addiction recovery clients, but really encouraging it and using it as a form of maintenance. And it was really controversial when I started doing that with even CBD and hemp derived in 1819. And then of course in 2020, when Dragonfly opened up, started helping our clients get med cards. they thought that I was the devil, giving drug addicts, this devil's lettuce, like you said. But since then, we've become the number one referral agent from the Department of Corrections for chronic reoffenders. These guys, not a 19-year-old kid in trouble the first time, but a 30, 40, 50-year-old guy who's a reoccurring heroin addict. You get a guy like that on a vape cartridge, and it can be magical. It's the most powerful harm reduction tool that we have to work with. And it's just exploded. The LDS Church sends us tons of referrals now. They see the proof really is in the pudding. This doesn't scare me that much. Kind of like you said, it is like Rich said, it's a small sampling that we're talking about. And I was already under the impression that these special courts, especially drug court and family court, could disallow cannabis. We've had a lot of clients that come back and say drug court isn't going to allow this. And I thought that was just kind of standard practice already. Where I would be afraid is if it bled into like general probation or parole, could be really detrimental because, man, it's not, of course, if you're a chronic pain patient or PTSD, it's going to be more helpful than that opiate or that benzo. But I'm talking about for addiction itself. Like, it's not a qualifying condition, certainly, but for reducing cravings and triggers, oh my goodness, it is remarkable. It provides a moment of pause between that trigger and that action point where you're going to go and find drugs. And if you're going to relapse, it's difficult. You got to find a dealer. You got to get cash. You got to go on the move. If you got a vape cartridge in your sock drawer, they hit that first. All of a sudden, maybe I don't want to go get high. It gives a moment of reprieve, this little moment to breathe. It brings some spirituality. It centers us. And it's been just magical. So I'm really excited for where cannabis can go and evolve in the addiction recovery community and grow, not reduce. I see your intentions are pure, I believe, because it's not right for everybody. Yeah, thank you very much.
I got a question for Shane before he leaves. If one of the folks living in the tribal house were a part of one of these drug court programs and they were asked to abstain from cannabis, what kind of effects do you think it would have on them and their treatment and their ability to kind of use cannabis as a maintenance or stay clean and sober, outside of their use of medical cannabis, and their ability to stay on the straight and narrow and not recede?
Well, of course, it depends on the individual. I mean, a lot of times these drug courts is a short period of time that maybe they could look forward to it afterwards. But I think it would increase the risk possibly if you took the cannabis away, especially if they're using it for, something like chronic pain. You don't want to give a guy an opiate, especially if he has history with opiate use. I mean, just as far as harm reduction, the fact that it's never caused a death and it really doesn't drain your bank account there's no withdrawals. If you stop suddenly, you don't find the violence. The parole officers love us. They're like, oh, these weed guys are a piece of cake. They're nice, gentle. They don't run away. They're where they're supposed to be. So there's really been a big shift. I'm excited to see where it goes and opening it up and having it less stigmatized. Thank you very
All right,
much.
thank you, Shane. All right, Justin?
I'm Justin Ariola. I'm speaking on this topic as a patient advocate, not a representative of my cannabis business. I just wanted to talk real quick on a couple of points that are kind of concerns when we start talking about legal changes like this. One, right now, you're still currently allowed to use substance use disorder to gain access to cannabis medicine. So if in the situation that was presented, if I had broken my leg, but I'm a former heroin addict, the biggest scare to me is going back on an opiate, right? And so I'm using cannabis medicine to treat pain to avoid having to go back on an opiate because it stole my life. And so when you get into a situation where you're either mandated to deal with your pain, which 90% of addicts out there are dealing with pain, that's what they're trying to do, or prevent pain from coming back on, to all of a sudden be mandated to either go back on an opiate or go cold turkey, but deal with your chronic pain, that's a terrible recipe for people who are actively managing their pain, actively managing their addiction, they're working. And so in particularly in vets, where that's a very near and dear topic to my heart, a lot of veterans who come up through the VA system have had to fight and push to even get access to cannabis. The VA is very historically favorable to giving you as many opiates as you want. They'll give you SSRIs, they'll give you opiates, they'll give you benzos. And so when we look at these programs, being forced to choose between living in pain, going back on an opiate, or just having access to cannabis, it's kind of scary to see that we would mandate somebody to backslide what we would consider pushing them forward progress. And I think that opinion varies from district to district too. And also in rural courts, the attitudes towards cannabis are very different from the city courts. And so the access to, hey, I'd like to have my QMP review this case. It's not the same for rural courts as it is for city courts.
Thank you.
Thank you, Justin. Is there any further board discussion? I do want to just mention it. I think as far as a program we've done over the last 40 years, there have been a lot of legislative changes and hopefully enough education, not really quite enough to show that medical cannabis should be seen as any other type of medication that the patient's prescribed. And when you're taking an individual that has been dealing with regard they're just the life situation they're found in, and now they're in a problem-solving court. They've already gone through a lot of just to get to that point. And so if we're preventing them from getting just any other type of medication that they get access to, and it's going to impact their life. I mean, I have a hard time as a medical cannabis processor to say, hey, let's limit someone's access to medicine that's proven to help them. And I like the points in there that were brought up that, you know, we want to see a collaborative effort between the doctor and the treatment provider and the QMP. And I think one of the biggest things that we're dealing with now is the patient get the quality of care that they're receiving from their QMP. And if we were to change their QMP through the courts, they're losing a quality of care that they've been receiving. And they need to maintain that relationship. And I think for me, at least at a minimum, I would love to see, you know, I think as written, I don't know, it's something that I can particularly support. If it were to come to the board later on with a change, they can specifically not call out and say, hey, we're gonna remove it. We're trying to work with the patient to make sure they still get the same care, work with the QMPs. That's something I'd be more interested in supporting.
You do have one hand.
Oh, we do have an online hand. Perfect. All right, we will let online commenter Mindy, go ahead and unmute you. You have 2 minutes. If she asks for more, she can.
Mindy, ask for more if you need more.
Okay, could you hear me ask for 3 minutes?
Yes, you can have 3 minutes.
Okay, thank you. So my name is Mindy Vincent. I am a licensed clinical social worker. I specialize in the treatment of substance misuse and mental health disorders for high-risk, high-need offenders. I am the founder and executive director of the Utah Harm Reduction Coalition. I'm a person who's recovered from a substance use disorder, and I'm a graduate of felony drug court in the 3rd District. I've been free from addiction since April 22nd of 2007, and that journey began with treatment court. I'm here today to share with you as a person with both professional and lived experience my concerns with this proposed change to Utah Code regarding treatment court participants in medical cannabis. First, I want to say that drug court did better than save my life. Drug court changed my life. Everything I have and am today is a direct result of the opportunity I was given to enter that program. It is something I will always be grateful for, and I will always advocate for others. At UHRC, we are one of the only providers in the state who will treat someone for a substance use disorder while they have an active medical cannabis card, which means I've had the opportunity to see many people use medical cannabis as a harm reduction tool to abstain from their drug of choice and to refrain from committing further crimes. Most of us know medical cannabis is a safer alternative than many prescription medications, and for those in recovery from a substance use disorder, safer alternatives are a must. People in recovery experience pain, nausea, sickness, PTSD, and many other conditions for which medical cannabis may very well be the most appropriate choice for them. Those conditions and choice of medication for treatment should be made between a patient and their doctor, not a judge and a drug court team. And no one should be refused the opportunity to change and save their own lives while making right their wrongs to their community because they choose with their doctor a safer alternative to prescription medications. I have witnessed and experienced firsthand the bias and stigma that exists amongst treatment providers and people in the recovery community in regards to medical cannabis, which is why I have grave concerns about treatment providers making decisions about someone's medications. Besides the fact that every one of us without a medical degree and license are practicing well outside of our scope. But the reality is when we deny people access to treatment and treatment courts due to medical cannabis, we are leaving them in danger of continued drug use and crime, and they may miss their shot to recover, and everybody deserves a shot to recover. And unless the cannabis use in and of itself is causing a treatment issue, there is not a need for it to be addressed at all. It should be treated just like any other medication is being adhered to. I would hate to see people denied this incredible opportunity due to legitimate medical cannabis use. And I just want to say really quick that collaboration is excellent, and that should be standard amongst all providers all the time. If people are working with a QMP that's not willing to collaborate with their treatment court, they need to get a new QMP. And clinical justification is equally as necessary. Clinicians have to be able to justify what those barriers are and how they're impeding them in court. I can see it in mental health court much more than I could see it in felony drug court, and I just want to make.
Thank you, Mindy. Your time was ended. No, I think it's good to get, I mean, obviously, that's a success story. So I appreciate her sharing her story and the message there. All right, going back to the board, does anyone else have anything else they'd like to add or any direction you want to take? Right. Yeah, I mean, I think, I don't know if there's necessarily is there any sort of action anyone wants to propose at this time, or are you just gonna?
Well, he's already added what we kind of all agree that there's two main things. I mean, I want to work with Rich on a fallback, you know, if we find a QMP or if we use compassionate use board or whatever, and fallback in case their QMP is not responsive or unwilling, and you know, I want to find something there, but if he's willing to put those two things, I mean, do we?
Well, it sounds like that's the case. If you want to take initiative on that.
Or do we
And
want to table it? Or do we want to table it until we have the revised proposal
Yeah, I mean,
and the final wording?
and then we can just vote on that.
Exactly.
Yeah.
Sorry, I didn't mean to interrupt.
No, I like it.
Yeah.
I like.
Apologize.
No, but I can go upstairs. There's two options you have today.
Yeah.
Right. I think tabling it is there. I think we can get the corrected language, and maybe again from today's meeting, we'll take some insight, and we'll see some further changes that will be more beneficial for patients.
Then I'll make a motion that we table it until we have stated information. Second.
You have a second? All right, we'll go ahead and do a roll call vote on tabling this item for future. Meeting.
Desiree Wilson? Yes. Katie Rose?
No.
Matt Page?
Yes.
Vincent Smith?
Yes.
Danette Perez? So. Candy Clark?
Yes.
Looks like Jimmy's on that one.
Oh, Judy Higgs.
Hey everyone, sorry I'm not there in person, but yes.
That gives us a majority of yes, table for future meeting. Okay, we will go ahead and move on to the next item. Item 6, so this is the impact of cannabis on opioid prescriptions and chronic pain, insights from recent research in Utah. And then whoever's presenting this item.
Two folks online,
Okay,
Natty and Jennifer.
you get them unmuted, so they can start the presentation.
Hey everyone.
Good afternoon.
Thank you.
So
Thanks for joining
Jennifer,
us.
would you like to share the screen with our presentation? Perfect.
Yeah.
And thanks for having us today. My name's Maddie Grant. I'm with Management Science Associates, and alongside of me is Dr. Lucero, who has been working on cannabis research for Management Science Associates. we're super excited to be here today and talk to you about some of the advances we've made regarding cannabis and correlation with opioid reduction and looking at different ways to analyze how cannabis correlates with chronic pain and pain management. So to start off, I just like to kind of do an overview of talking about leveraging real world data. Dr. Lucero is going to go into the actual studies. So Jen, if you don't mind changing the slide, that would be great. Great. So just to start off, a little bit about Management Science Associates. So we were founded in 1963. We've been a leader and pioneer in data analytics and software solutions. Our experience with information management and data integration goes across a lot of different industries. That includes the healthcare space, consumer goods, media, and more. We expanded into medical cannabis research in 2013. So with that, we've really seen, the necessity of education and research in this space. And we try to use and support our strides in research through our data and our de-identification engine. So a little bit of our de-identification engine, you'll see here, you'll see HIPAA compliant, privacy protected. So our DID engine is HIPAA compliant. It's used with cannabis operators' point of sales data. With that, we're able to match, tokenize and anonymize the data and match that with healthcare data sets. So those healthcare data sets we'll talk a little bit more about in the next slide, but really this slide is to show, over our 6 decades of research experience, really to make sure, patients are protected. Now, this slide here, we're showing some of our real world data sets and where they come from. So you can see we have National Consumer Purchase Panel data, lab test results for approximately 200 million lives, electronic health records, so approximately 30 million lives. You'll see the cannabis point of sales data. This is where we begin to correlate these data sets. So we see 110,000 cannabis consumers for approximately 30 dispensaries, and that's growing. Medical claims data as well, and digital behavior data. So, of course, with cannabis and medical cannabis, we see research, kind of at a halt as far as clinical trials. I mean, we see a lot of anecdotal and survey-based data, but really, because cannabis still sits on the Schedule I status for the Controlled Substances Act, hopefully with rescheduling that will kind of change the game. But really with our real world data, we're able to move the ball forward and get more insights into how cannabis is correlating with specific health and wellness needs. Eventually we hope to strive for more clinical trials as we approach rescheduling, and the DEA approaches their hearing on December 2nd. But really, this is where we want to kind of move the ball forward. We want to work with operators. We want to see from a real world perspective how the cannabis data is correlating with healthcare data. And this is where I'll just go over value of real world data in healthcare. So real world data in healthcare, we have data collected from patient interactions, prescription records, dispensary sales. So those are correlated, and we see, 2 different data sets, and they are anonymized. So completely privacy ensured, and making sure that is, that's something that MSA is an expert in. We see valuable insights, so we can look at different products and how they're correlating with opioid reduction and other ailments. We can look at cannabinoid ratio, looking at THC versus CBD. We can look at types of products too, demographically, what are they using in correlation with getting off and reducing opioids. And from the potential impact, one of our main goals at MSA is usually when we conduct a study, we partner with advocacy groups. We've been working with the American Cannabis Nurses Association and other groups that really need this education when they're talking to medical patients. You have a lot of subject matter experts out there in cannabis, but not necessarily, from a healthcare perspective. So we're trying to overlap and educate from a high level. And this, of course, provides an alternative to opioids as well. Looking from an observational study perspective, how can this help, reduce opioid use just in general? Obviously, this is a big concern across the United States. In Utah, we saw that 52,000 individuals aged 12 or older had some sort of opioid use disorder, and then 627 drug overdose deaths reported in 2027. So really, our goal here is to find alternatives and, see if cannabis is an alternative and really develop out this research. So here, this graph is from Utah's Department of Health. We saw, a decrease in opioid deaths by year starting when medical cannabis was legalized in the state. So, you see a gradual decline. So we're trying to really get our minds behind this and use our de-identification engine to explore it further. And research is crucial to do that, right? Everyone needs data. You have operators that are looking for data. They want to educate their medical cannabis patients, and so they can make the right decisions for themselves as well. And again, just going over opioids, chronic pain, and cannabis research, we see that chronic pain is a major driver of long-term opioid use. There has been a growing interest in non-opioid alternatives for managing chronic pain. And medical cannabis has shown promise in reducing use of providing pain relief. So I'm going to turn it over to Dr. Lucero, who's going to go over the actual study that we conducted in Utah, and we'll circle back after that.
Thanks, Maddie. So our study builds upon previous research that suggests that cannabis can reduce opioid use and improve pain management. So in 2014, a study conducted by Backer and other researchers found that 25% of opioid overdose mortality rate in states with medical cannabis laws. So that was a reduced overdose mortality rate. In 2016, there were 3 studies that found significant reductions in opioid prescriptions for pain. And one of them, a cross-sectional survey of 244 patients, found a 64% reduction in opioid use. And later in 2017, a cross-sectional survey by Piper and others found that among patients that regularly used opioids, 77% indicated having reduced their use since they started medical cannabis. So a reduction was also seen in other medications prescribed for depression, anxiety, insomnia, and migraine. However, in 2018, a 4-year cohort study by Campbell and others found no significant opioid reduction with cannabis use. And then later in 2019, a group of researchers found that they used a mobile application to collect data to measure self-reported effectiveness and side effects of medical cannabis. And patients were asked to report symptom severity on based on a visual analog scale before and after starting cannabis consumption, along with experienced side effects. And they found that cannabis was being used to treat various health symptoms, and the most frequent were related to pain, anxiety, and depressive conditions. And they concluded that cannabis was associated with a clinically significant improvement in self-reported symptom relief. In 2020, a study of 97 patients and a systematic review of more than 70,000 patients from 9 studies found a significant opioid dosage reduction. In 2021, McCallum and others concluded that a low dose of THC introduced as an adjunctive therapy for non-cancer patients was associated with better pain control and lower doses of opioids being used. And in 2023, a large study of more than 8,000 patients found that there was a significant reduction in prescribed opioids. So what the previous literature tells us is that cannabis is a potential adjuvant or alternative to opioids, but more research is needed on its direct impact on reducing opioid overdose risk, and also on the specific products and concentrations that could be effective for different types of pain. Based on this, we have started to analyzed data from cannabis users and opioid prescriptions on a state level. So in Utah, the objective of the study was to evaluate the impact of medical cannabis on opioid prescription reduction among chronic pain patients. The data, we designed an observational, self-controlled, retrospective cohort study using point-of-sale data linked to electronic health records from 186 patients with chronic pain from 2021 to 2024. And the preliminary results showed a 53% reduction in opioid prescriptions after initiating cannabis use. So the data from cannabis product transactions was provided by Dragonfly's point-of-sale system, and it was de-identified using MSA's HIPAA-compliant de-identification system to protect patient privacy, and then matched to each patient's electronic health records. This gave us access to the patient's vitals, medications, conditions, laboratory tests, and other clinical data to be used for research. The variables we analyzed were opioid use in morphine milligram equivalents per month. This is a standardized measure that allows for consistent comparison across different opioid types and dosages. Cannabis use was classified in periods, 6 months before and after the first purchase. And we also analyzed demographic factors such as age, sex, ethnicity, location, and different product types, cannabis product forms, and THC-CBD ratios. For the statistical analysis, we described different demographics, pain types, and cannabis product types in this group of patients and compared the opioid prescriptions in MME per month between periods before and after cannabis use. We used a prediction model, a linear mixed effects model, to account for individual and multiple patient observations across time and to account for incomplete data that was found in electronic health records. We controlled and adjusted for covariates to make sure that the results were not influenced by other factors, demographics, and also identified different patient characteristics and product types linked to reduce opioid use. So what we found was a reduction, like 84% of patients were able to reduce opioid use after starting cannabis. The mean MME per month before starting cannabis was 3,832 MME per month, and it went down to a mean of 1,798 MME per month in the period after. We have an overall reduction of the mean MME per month of 53%. And when we ran the predictive model, we found that we adjusted for other variables and we observed a decrease of 343 MME per month in the period after starting cannabis use. We had for the predictive model a p-value of 0.07, which is in scientific research, we call it marginally significant. It means that there is a 7% probability that the observed results could have occurred purely by chance. And we have to add additional data and additional analysis that is needed to confirm the results. In this group, we observed that the mean age of patients was 49 years. And the majority of patients who reduced opioid use were 36 to 65 years old. We analyzed also gender, and we found no significant association between males and females in the group of that experienced a reduction. There was 56% females. When we looked into different types of pain, we found that the greatest reduction in MME per month among patients was in patients with neuropathic pain. So neuropathic pain arises from damage to the nervous system as seen in conditions such as diabetic neuropathy, post-herpetic neuralgia, and carpal tunnel syndrome. And this type of pain is particularly resistant to opioid treatment. and often it leads to patients to increase their dosage to attempt to achieve relief. So this is something that could raise the risk of overdose. And it also contributes to a condition called opioid-induced hyperalgesia. So in this condition, when prolonged or high-dose opioid use makes patient more sensitive to pain rather than providing relief due to changes in the nervous system. So this underscores the importance of distinguishing between different types of pain and identifying the cannabis products that are most effective for each, because not all products could work the same for different patients. Interestingly, patients with chronic headache or orofacial pain showed an increase in opioid use in this group of patients. We also saw that the most prevalent cannabis forms in the group that achieved reduction were vapes and gummies, with a 67% and 53% respectively. And we can conclude that cannabis shows a potential in reducing opioid use for chronic pain management, and this aligns with previous findings in other studies. We have conducted a similar study in Minnesota showing a 30% reduction in opioid prescriptions. And what we also found in that population is that in terms of product types with a THC CBD ratio of 1:1 were more effective to reduce opioid prescriptions in patients with neuropathic pain, whereas a ratio of 19:1 was more effective in patients with musculoskeletal pain, such as back pain or osteoarthritis. We know that cannabis may offer a safer pain management alternative, and this could help reduce opioid dependency and improve patient outcomes. For this study, the limitations were that the data on medical cannabis transactions was provided by a single dispensary. So we expect that we get data from more dispensaries to increase the generalizability of these results. We used a self-controlled study design, and this approach is valuable because it minimizes the influence of individual differences like genetics, lifestyle, and other baseline factors that could affect outcomes. So in that sense, it makes it easier to isolate the effect of the intervention itself, but we are working to include a larger and more diverse sample size that would allow us to add an external comparison group with sufficient data on each type of pain. And this is important because when we categorize the pain according to the latest classification by the International Association for the Study of Pain, the number of patients within each group, within each pain type, reduced the sample size we needed to obtain significant results. So for the next steps, we aim to secure the linking of medical records and medical cannabis patient registry data for chronic patients with point-of-sale systems from dispensaries across Utah and nationwide. And we aim to collect enough data to build a national database for cannabis research that could be available for other investigators to conduct their own studies and increase the production of high-quality evidence. An integration would enable a long-term analysis and possibly prospective studies and expand into other conditions such as insomnia and anxiety, and guide better cannabis use. Thank you.
Thank you very much for that time and that presentation. And as I had a chance to kind of look through it, I think there's a lot of impactful information that could be drawn from this. And
so
yeah, go ahead.
Yeah, and I sorry about that. I was just going to conclude to, like Dr. Lucero mentioned, we're seeing promising results from the studies that we conducted in Utah, Minnesota, working on a study in Pennsylvania, California. So we just want to, open the conversation and just, have obviously we've looked at opioid reduction and, we can look at other ailments, but just happy to be here today and present this data and be collaborative with, you all and, Utah's Department of Health and Human Services and Department of Ag and Food as well. So happy to take any questions. We appreciate your time.
For questions for them? I don't necessarily have any questions. I think one of the things, I mean, in researching and kind of reading through this, is we do have the Cannabis Research Review Board, as well as the Center for Medical Cannabis Research at the University of Utah. I think, if this, depending on the scope of the study, obviously, you know more than I do myself, to the size of the United States. Is this something that would be beneficial for that board to review and potentially maybe trying to do their own within the state of Utah?
Well, I think it's worthwhile for the board to look at it. Usually the board looks more at randomized clinical trials, which this isn't, but this is more of a, it's a smaller subgroup, obviously. I think it could be reviewed, but the scope is different from what the board typically looks at when we're tackling a topic or an area. So.
Is it something that the research center, if there's anyone that's involved in the research center that's seeking to do this kind of research area?
I think the epidemiology department I think that epidemiologists would be the department to speak to.
So that's who we should reach out to at the research center.
Well, in the acting chair of the steering committee for the Center for Medical Cannabis is involved in some of that work as well, so.
Because Rich, didn't they do a study or are still conducting a study on chronic pain? Is that being concluded or is that still ongoing?
It's ongoing.
It's ongoing.
Yeah.
Right. Some of the surveys have been done and they're ongoing because they wanted to have like a benchmark that they're starting at, and then they do another survey in 6 months, and then I believe they do plan on completing in February, and then thereafter releasing some of the results of their study after that. Yeah.
So maybe to the extent that these ladies would like the contact information,
Yeah.
I recommend that the board pass that along to them so they can make those connections.
Yeah, Trevor can make that happen. Absolutely.
I think it's beautiful work so far. I also think it could be strengthened even further by, and this could happen through the center, is they could also maybe establish a collaboration with some of the core statistical groups. Because I think when you look at the before data, there's enough variance that an analysis of covariance is going to be necessary to really validate some of the variances before to after. So I think it may even strengthen some of the statistics. So, but I think there's a lot of opportunities to dig even deeper into the numbers you have here and maybe even bolster some of the other studies that are happening currently.
Yeah, and just to add too, we also did speak with the Center for Medical Cannabis Research. It must have been a couple months ago. We talked to Valerie and Gerald over there, and they were very interested in what we were doing, but they, I think they kind of had their hands tied with a couple of different projects they were working on. But always great to collaborate. This real world data can definitely add some variance to that survey based data and such. So we're happy to have that conversation again.
I also know some investigators would be very interested in the migraine data that you presented because it's really unique.
Great.
We do have some individuals that would like to present some public comment. We'll start with those in the room, and then anyone online, please raise your hand, hit the little raise hand icon so you can be called upon when we get to that point. We'll start with Tim Pickett.
I'm Tim Pickett, kind of the MD. I just want to applaud the researchers for doing the work. I think that, reviewing the data, this is somewhat similar to the results we get in clinic as far as the opioid reduction. There's certainly some things that I would love to dig into, like Misty mentioned, right? And the variance on outcomes. But as far as this goes, we need the data to back up the system or we don't get anywhere in the hospital to create the algorithm that does the work.
Thank you, Tim. All right, Nareth?
Thank you, distinguished humans of the board, Nareth of Dragonfly. I say humans because as humans, we are all subject to our own confirmation biases. Every single person sitting at this table has a belief about cannabis, and it informs our decisions, the way that we look at our day-to-day jobs, and the lens in which we view patients in our community. And if we all can't sit here as a board and agree on common facts and common things, that I don't see how we can actually move forward and make informed public policy, right? That's the reality. Everybody has their own belief. I grew up in the DARE program, right? And I had to overcome a lot of challenges and stigmas on what cannabis is. To be on this side of the table and to be speaking as confidently and passionately about cannabis as we do. And I recognize that some of you don't believe the same thing about cannabis as I do. So how do we get on the same page? And unless we can actually stop talking in circles about we don't have clinical trials, we don't have research, we don't have this, we're all sitting here looking at each other. And we are a board designed to make policies. And if we keep going back to we don't have conclusive evidence, we don't have data, nothing changes. So I think what we have here and the testimonies of people like Mr. Dressel and Shane and Mindy from Utah Harm Reduction, this is not anecdotal data or evidence. When are we going to stop saying this and actually do real research, real science, put our money where our mouth is, be progressive about making change in our healthcare system? We have that opportunity. We have that power. We can do this. We don't need to wait for the federal government. We don't need to wait for other people that don't care about cannabis to tell us what to do with cannabis. We have real data and real information and people in this room that want to make a difference in our community. What do we do next with this data? Where do we take it so every single person in this table can accept that this is the truth? And then we can maybe make some public policy that maybe makes it a little bit more accessible for people to get access. Maybe instead of prescribing opiates, we prescribe cannabis right out of the gate. But if we don't believe that it can help, we're all sitting here in the same positions. Thank you, everybody.
Thank you, Nareth. We'll turn. No.
Oh.
There's anyone else in the room? If not, we'll go online. Valerie, you have 2 minutes.
Thank you. Yeah, I wanted to just point out that, we did actually invite several people from the steering committee to join. So hopefully they were able to attend the call. In addition, Trevor did a great job of connecting with us early on, and we had several people interested in this study data. So to Misty's point, it's definitely something that I think our researchers would be interested in. And as Misty and JD and Rich pointed out, we do have our MCOR team here in the state that does the evaluation also looking at this. But I do want to thank MSA and Nareth for reaching out. And I think too, a bit of to speak to a little bit of what Nareth is saying, and this is a great opportunity and a way based on what is going on federally for us to begin to create correlative approaches that allow for us to not only work within those groups within our state that are trying to find different research approaches, but to kind of create the community that I think, Nareth is speaking of, that allows for us to kind of further the conversation. So I think this is a great way for us to start looking at real world data and kind of taking an approach for what we might be able to do within our own research program here. So we intend to have a few of our pain physicians take a look at this information. And if need be, we'll reach out to MSA and NARIC for additional conversations. But I do think this is a really great start to kind of creating the types of relationships that are possible for us to get more granular around what research we do to impact the public specifically here in Utah. So thank you all for kind of including us in this, and we'll be sure to utilize it however we can.
All right, thank you very much. One question, Rich, or maybe you know, the study that's going on right now, are there certain benchmarks they're looking for that they can start providing updates? Like, how long is this study going to last until we hear something? I mean, is this a multi-5-year study and then we finally get a result?
So I think March of 2025 is what they expect at this point. Yeah.
It may be good, again, in the future, if you want to take a note, Trevor, is
Battery.
oh.
Yeah.
And battery, yeah, I think in January, there might be some data presented.
Yeah, so we'll be, hi everyone. So we'll be hosting our symposium in January, and the evaluation team plans to give an update as far as where they are to this point. The great thing about this study is that we do, as Rich said, see it to be ongoing, with the goal of doing the initial data linking, which also will include IHC within this year. We're hoping to get it done within this upcoming year, with the goal of trying to get things basically settled before any of the legislative sessions next year. So they're in progress and should have the capability of giving updates by May of next year as well. But they're basically focusing on the overall interactions that people have within the system, within the program, as well as opioid usage, but other substance use as well. There's several different points that they've taken in consideration, but that's the main focus of the data as of now. So I'm not sure. Jerry may also be on the call. If I know he had planned to attend, but may have had to jump off. So he could give additional information if there's more questions.
Sorry, let's see.
Can you hear me?
We can. Go ahead.
Yeah, so very interesting stuff from MSA. That sounds like it has some great implications. Yeah, in our study, we have a couple of different phases of it. And as Rich indicated, we're targeting our final report for the prospective cohort study for March of 2025. And then we have 2 phases of a larger project where we'll link, as Valerie alluded to, link the prospective cohort data to medical records at University of Utah and Intermountain Health. And then the second phase will go as things work out. Of course, it's a process, of course, but we're hoping to link, bring in medical claims data to what's known as the all-payer claims data for the state of Utah, and trying to look at some of these things as MSA has already. I think for these outcomes, I will say I think MSA, their data, if I remember correctly, is based in medical records, and that'll be similar to what we'll do with the prospective cohort. But for our larger component, that'll be claims data. So that'll be actual medications dispensed instead of just orders. It'll be like dispensations of medications and things like that. So, and like procedures and kind of actual claims paid for. So anyway, yeah, we're looking for it. We think it'll be an exciting thing to complete those different phases of the project and to put out some of the results. And Yeah, so it's a great opportunity, and I'm glad that MSA was able to present today and give us some of their findings, and hopefully we'll be able to add in the upcoming months.
All right, thank you very much for that insight, and I think it's, as we move forward, I think ideally it's how can we utilize studies and research to help benefit Utah patients, and in particular, there are several conditions that are not seen as qualifying conditions, that if we could utilize the Center for Medical Cannabis Research to actually start performing research on those particular issues, and then make not just anecdotal qualifications, but have some research and backing behind it, showing that, even if it's one person that goes in with a condition, we'll just say anxiety is not on the list, and it's showing that medical cannabis can help, and it's a study. I think that obviously if there's one, there's going to be a second. And people should be able to get access for every condition they have. And so I appreciate the time and effort that's been put into this today, and get in there. Is there any other discussion or comments from the board that you'd like to make?
Thank you.
Okay.
Yeah.
I thank you very much. And Eric, do you have something else you want to comment on?
We look specifically at chronic pain here, but guess what happens when you go down the list and look at other conditions and see reduction in other prescription drug usage? We're looking heavily at insomnia right now because it's not a qualifying condition, yet we have a lot of people in our program that have insomnia and are using cannabis otherwise, right? So these are the type of real world outcomes that we look at, because we know that we've got, these studies that everybody circulates that don't even use real cannabis products, use synthetic products, use epidiolecs and other things, and we know those are not efficacious products. So we're looking at data that actually doesn't really matter, and what we're looking at is data that is based on real patient outcomes of what people are actually buying and utilizing. So I think there's just a lot of value in looking at that, and we can take the next steps. And I know we're working on next, trying to figure out this insomnia question, right? Are people actually really finding relief and reducing other prescriptions that they're counting on that are also very harmful and addictive in itself? So.
All right, thank you.
And I would really strongly encourage you try and publish this. Because the more the information gets out there, the more accessible it's going to be. So.
All right. I appreciate. We'll go ahead and move on to our last item. Let's see. So medical cannabis payment providers. We do have Mr. Christensen, the director of the Division of Finance here, who has a brief memo to discuss with us.
Hi, as was mentioned, I'm Van Christensen. I'm the director.
Maybe speak a little bit louder.
Okay.
Yeah.
The reason I'm here is we, in state statute there, and this is in Utah Code 4-41A-108, and it basically says the Division of Finance will do some monitoring over payment providers for those who dispense medical cannabis. And so a payment provider is anyone who kind of facilitates between a merchant and a bank and an individual, things like that. So it could be like a credit card, a debit card, things like that. So what this law requires is that requires the Division of Finance to do some oversight and review of those payment providers, and then provide a list of eligible payment providers. So as we look at the statute, it basically tells the Division of Finance that you're to create a rule, which we've created an administrative rule, which gives us some things that we do. I'm relatively, well, I've been in this position a little over a year. And so as we kind of look at why do we do certain things, this was one that I started asking people, does our rule really do what the statute requires us to do? And I don't know that it does, which then led to the next question, is the statute still necessary? Which is part of the question I have here for now. So we didn't want to move ahead with making any proposed changes or things like that without getting some input as far as, is this work that the Division of Finance does still necessary? If it's necessary, what are the risks that we should be trying to monitor these payment providers for? There was, and I believe, I don't know if the survey was done by this board, but I know that there was 4 MRBs that were reached out to see if
this is a necessary service, and all four responded that they didn't feel like it was. It was kind of an unnecessary administrative burden or barrier. So we are happy to do what's necessary and needed. We don't want to create a burden for anybody or get in the way of anybody. So I guess that's what our proposal is. Before we go and propose legislative changes, we wanted to make sure that we're getting input from those who understand the industry to see what would you like us to do in this area. I guess that's what we're thinking.
Thank you, Mr. Christensen. So yeah, I mean, there was a survey sent out by the Utah Department of Agriculture to those within the industry. It essentially had these similar questions, whether or not we felt the Division of Finance should be helping in monitoring and assisting with payment processing. I think the overall consensus was no. I think it was just an added layer of thing. Now, I think there were some questions in there that came up is are there any protections that as a cannabis company that they receive by having the Division of Finance approve payment processors?
So most of the things, as I looked at kind of the rule as far as what is it we're doing, there are things that like banks and financial institutions have to do, and there's already a monitoring function that does that. So I kind of felt like we were duplicating something that whether it was the State Department of Financial Institutions or other. For example, if you go to a bank and you have a transaction over a $10,000 limit in cash, there's certain reports you have to fill out and do that. We were getting certifications to make sure they're complying with those types of things, but I felt like that was duplicating things that other regulatory agencies were doing. So I do not believe, from what I understand, that there's any additional safeguarding or security as far as making sure payments are actually processed correctly from what we were doing.
Are there any payment providers that have applied, you guys have declined?
I'm not aware of them.
Can I call phone a friend?
That was your one and only question.
I thought I'd ask it anyways. And I can say, we are one of the businesses that did respond. I work for Suco, and we did respond, and we find it to just be more bureaucratic red tape, and that it's just another checkbox that doesn't seem to necessarily be necessary. And if we are already doing this, on our own. And I can also tell you too, it does dissuade some payment providers from being willing to do that. It's not required in other states. And with the volatility of the payment space in cannabis, because it remains federally illegal, having the ability to be able to nimbly switch between payment providers, or at least more nimbly switch between payment providers, especially when patients have become accustomed to making those types of payments, for their cannabis, to say, hey, we're still the one place in the world where you have to go cash only. That's really hard to try to, retrain, patient behaviors. And if it any way, shape or form, continues to add to the 56,000 patients that have left this program because they can't use a debit card because, they aren't willing to go through the payment provider, approval process that really, for lack of a better term, seems like a checkbox at this point. I would, I probably will make the motion, but, I would be in favor of removing this as a requirement. And I think I got the answer that I needed, that no one's been, not approved. I think if there was a situation where you could say, hey, yeah, we've approved 5, but 4 didn't meet the criteria or 3 to make the criteria, it would let me know that it's probably more than just something that's, pro forma. It's something I think that's been given to you guys by statute, but hasn't proved to be terribly useful for you all or for, us as an industry. So that's kind of my 2 cents on it.
I think my understanding with it is we're mostly dealing with banks who start declining transactions, not payment providers. They find out who it's coming from, and it's the bank.
Yeah, I mean, more than anything, it's the Visas, it's the MasterCards, it's those, they shut the payment rails off and things like that. Now, look, if I get on my soapbox and talk about the federal government needs to take action, this is one of the reasons the federal government needs to take action on cannabis and really should deschedule cannabis completely from the Controlled Substances Act. And then we can use credit cards and debit cards and anything like any other consumer, consumer good. So, but I think everyone knows that. So I'm not telling anybody anything we don't know. So.
Can I make a comment
Yes.
really quick? I was just looking on your website. It looks like there's 7 companies that have been approved, right? CanPay, Solvent, Utah First Credit Union, To Accept, Skylight Business Services, Transact First, and Vector Payments. And the only one that strikes me upon first glance is one that would act as either like a bank or a credit union would be Utah First Credit Union. And it seems these others are just processing electronic payments, right?
They're not a bank.
Yeah. And a question for JD. Have you heard from businesses in other states that have had trouble with some of the payment providers that have tried to enter the space and have caused problems?
None that we've, reached out to or established relationships with. Obviously, that's part of what you do. But part of it too is it's not necessarily the payment providers themselves. It's the volatility of the space, right? It's okay one day, the next day it's not okay. You know what I mean? And it's really more just federal banking around cannabis and generally whatever the whims of Visa and MasterCard becomes, and it's hard because, and so what you look for is you try to create as much stability as you can, but for your patients to say, hey, yesterday, your debit card worked just fine, today, it's all cash. That might seem not like, too much for someone, but especially if you're a homebound patient or someone like that, getting to an ATM and getting cash, and most people just carry plastic in their wallet nowadays anyways, and so we haven't experienced that, and obviously we do our best to vet them to ensure, because for us, it's important that they're going to be a long-term solution, not like, oh, hey, you're gonna work for a month, right? And then we're gonna have to go find another one, but that's the volatility of the, of the space. So a lot of what it is negotiating good contracts that give you optionality, don't lock you into exclusivity and things like that. But yeah, most people that we're getting in touch with, obviously we're doing the vetting, of them. Before there's any sort of agreement, signed with them. And if anyone were to raise a red flag, about them as a payment provider, of course, then, we'd be interested in working with them. But like I said, I think it's more the general volatility of the space that creates problems and not the payment providers themselves.
And I just have a quick question, if I could, for Van. So you've received over the years just a total of 7 applications? Or some, does that happen where sometimes I'm just curious.
Let me bring you a chair. So this is right here. Okay, so right there. So this
I
is,
took a wrong turn.
this is Jen Vallejos. She supervises this program directly, and so
okay,
she can help me a little bit with some of these.
So I can't tell you the exact number of applicants that have applied, but many of them don't follow up when we start asking them for all the documentation that we need. Then they kind of turn around and then we never hear from them again.
Got it. Okay. That makes sense. Okay.
It's Vallejos, Vallejos.
But for those that do submit the full application, those are the 7 that have been approved, and there's not anyone that submitted a full application you denied, like, their ability to be a payment processor in Utah.
Correct.
Okay.
So there was one person, there was another provider that we recently took down because they didn't do their annual renewal.
Okay.
So we couldn't contact them to get them to renew. So we have removed them from the approved providers list.
Was that Hyper?
I'm sorry,
Okay.
I don't remember,
No.
but I do know that there is one provider that's on the approved list that we have heard controversial comments about, but we don't know that, it's our place. Like, we don't have authority now to say like, well, you provided all this stuff, but now it looks like there's legal action against you. So we're pulling it. Like, we feel like we'd set ourselves up for legal action if we did that.
Sure.
Because they've met all the requirements that we've established in place. And so
It's a question whether they're a good business or not, and that's how we're in the business side. There are certain requirements they have to meet. And if they meet those, you're obligated by statute to approve them.
for the most part, the statute basically tells us to identify what the requirements are in rule. And that's where it got a little tricky for us because we were trying to understand what is the risk we're trying to address? And I think there may have been a risk when this was initially established or set up and maybe some concerns. But I kind of wonder if those risks no longer exist. One of our thoughts.
Do you know what those questions were?
Yeah.
To address the risks?
Well, I know what the questions were. I don't know that our concern is when we looked at what the statute required us to do as far as we were to establish standards
to make sure that these transactions could safely be conducted. And so as we did that, a lot of the standards we established, they had to do with, hey, do you compliance with suspicious activity reports or currency transaction reports, or compliance with some ACH transactions type things. But a lot of these, what we did was we got certification, or it was basically self-certification by the entities that did it. And so it didn't provide a lot of value, I don't think. And so the next step for us, if there really is value, and this is where we kind of started talking, is we probably need to verify or validate rather than just self-certify if we really have something we're supposed to do here. But then it kind of led to the next question. What is the concern? What is the risk we're trying to address or look at? And I don't feel like the steps that were outlined in rule, essentially, I don't think they do anything that isn't already done by other regulatory bodies, I guess is what I'm saying.
And maybe Rich, you can correct me. I'm trying to remember, but if I remember 100% right, when everything was started here, I think they were just trying to make it so it wasn't just a cash only. That it wasn't there. And I don't know if there's like concerns of somebody using that in some illegal way, just cash out off the road, but for whatever reason, that's what sticks in my mind, that they're just trying to make it so it wasn't going to be just cash only, but.
Yeah, and I think at that time, there were some states where there were some companies that were jumping into it that were immediately jumping and changing their name. That's what I remember coming out of other states. And just, they're shut down because of the credit card companies finding out, okay, they're just going to go and open up another one, right? So I think that was a factor. But yeah, I mean, it's important to just reach out to lawmakers. There could be some that, that have some banking background that would have more concern about this than has been expressed here.
Yeah, but I think obviously the feedback you received from within the industry is there's no concern if you're not involved. The more concern is if you are, just adds that extra layer. And to kind of what we've heard from comment is that we may be missing out on certain providers. Obviously, there's a long list. And again, that should be for the business to decide if they're going to continue to use that processor, because that's just a risk for them.
Right. I think that's a decision the merchant should probably make and kind of address that. So,
okay. Are you looking for a proposal today? Are you looking? What's your outcome that you're looking for today from this?
Well, I guess what we'd look for is a recommendation, I guess, or support. And I don't know who does this, whether it's this board or whether it's us that opens a bill file to potentially amend this law. Now, if there needs to be more research, we're certainly open to that. And so I guess if we move forward, who, and if we don't move forward, then what additional information we need to kind of know what we need to do.
Yeah. Yeah, I mean, ours is, we're just an advisory board, so all we would be saying is, we advised legislators that we don't feel there's a need to have the Division of Finance reviewing payment processors. That would.
Sorry, you answer. I just want to raise my hand for when you're done.
No, you go.
Okay. So we had some conversation before then. We recommended they come to you guys just to talk about this and get input, obviously. And it sounds like going with the way the board, I believe, is going to go here. What we can do is we can help set up from the Department of Ag's portion. We talked before, at least a meeting with Senator Vickers and to start that conversation, because I don't think it'll be too much to remove that. That's what's kind of decided. And he was definitely the one at the very beginning. So maybe he even has more information, but we can set that meeting up between us and him and maybe some other lawmakers and get this thing rolling. So.
But I think it'll be helpful to have a recommendation from the board if somebody wants to propose one.
Yeah, sure thing. I'll make a motion that we make a recommendation to lawmakers to amend Utah Code subsection section 441A108, which requires the Division of Finance to approve payment providers in the medical cannabis space to no longer require the Division of Finance to do that approval process.
And we second it.
Right, we have a motion. We'll go and take a roll call vote. Give Abby a minute. That easy. Yes.
Yes.
Katie Lorenzo,
Yes.
Judy Hanks,
Was that me?
yeah.
Sorry, I couldn't hear you. Yes.
Desiree Hennessy? Yes. Tammy Park?
Yes.
Nanette Beresney? Yes.
All right, that motion is unanimous. We will provide you with that recommendation and you can work tomorrow. You'd have said.
There we go.
We're done with that. Okay. Thank you very much, Mr. Christensen.
Thank you.
Thank you.
So, we'll go ahead and move to the next item, which is just next meeting's agenda. What is that third Tuesday?
17th, I believe.
Okay, how's everyone's holiday plans coming along?
I know, I'm not.
These last week before Christmas, so hopefully all your shopping's done by then.
We can shop online during.
Oh, perfect. Okay. Is there anything in particular that the board would like to get onto the agenda to talk by then? I think we're gonna start seeing more bill files come through. We might have stuff coming from the legislators.
Yeah, that's what I'd say. It's just us. And I think also to be prepared to maybe have a longer meeting when we get into February or even January as those things come along, or multiple meetings if we need to.
Yeah, February and March will probably be the busiest ones for us. So, well, yeah.
Our thing is, this meeting, like today, does not land on another important county meeting. We have 2 meetings a month that have to be, and it's happening at the same exact time today.
Yeah, we didn't mess up a meeting. So.
We can work on that.
Yeah, and then to the extent the agendas come out ahead of time, I mean, even as the EAC, it wasn't about the agenda till about 4:30 yesterday afternoon, right? Everyone here knows that. So to the extent we can do that, that's great. But I mean, sometimes it just is what it is. And if we need to move, like we did before the meeting, to an earlier time, or things like that, we can do that as well. Because I do think it is helpful for the folks that are here, especially the folks who don't live and breathe this every day, like Matt and I do, or Des does, to go to those meetings. I think it's important to see the sausage get made. So
Yeah. So what we may do is just reschedule those, the meetings that we had in those months when we had interim for a different day and time.
Yeah.
And we'll just
try to make it work as best we can. Like
yeah.
And then it really didn't matter. So we got a meeting that didn't matter. So okay, well, if there's no other item, Trevor, you have an item?
I just want to confirm, so long as the judicial council can provide a revised copy of their proposal, you'd like that to be on the agenda next month, is how I read that motion to table.
Yeah.
Okay.
Yeah.
Just
and I mean, we won't necessarily need 45 minutes to discuss. Obviously, it's already been discussed. So, okay. There's no other item of business. I'll take the last motion of the day.
Motion to adjourn.
Second. Have it seconded and approved. Okay, thank you very much, everyone. Thanks for everyone who joined.